Good morning. Welcome to the First District Court of Appeal. We have three cases this morning. Between the first and the second one, we will have coffee with counsel in the rotunda, so please join us for that. The first case is Abpaymar LLC versus Richard W. Campanero et al. Mr. Stoper, are you ready?
I am.
You may proceed.
Thank you. May it please the court. I'm Mark Stopa, counsel for the appellant. I would request 3 minutes for rebuttal.
Would you stand closer to the mic, please?
Sure, Your Honor. I'd request 3 minutes for rebuttal. Your Honors, my opponent convinced the lower court to vacate a final judgment more than 1 year afterwards based on defective service of process. They spend a lot of time talking about due diligence, but before we even get there, their entire argument, both below and in the brief in this court, is based on 3 different false premises, which this court should reject when it reverses the order at bar.
So what's our standard review to start with?
On the first issue, it's de novo. And that's one of the issues I wanted to clarify. The first issue is simply a legal issue, is can one defendant challenge the sufficiency of service on behalf of another? That's a purely legal issue that gives rise to de novo review. And that is an issue of first impression in Florida that I'll talk about here in a moment on the merits. In terms of generally a 1.540 is reviewed for an abuse of discretion. So to the extent that there were the underlying ruling on the due diligence issues are an abuse of discretion, but it is clearly a de novo review on the first issue, and that's where I want to start. That's the first false premise. The first false premise of my opponent's argument is that J.P. Morgan Chase can come into court and challenge the sufficiency of service of process on behalf of a different entity, Washington Mutual. And make no mistake, they were different entities. They don't allege there was any merger or anything like that. Now, as far as I can tell from my research, Florida has yet to adjudicate whether one defendant can challenge the sufficiency of service on behalf of another. But I did extensive research in other jurisdictions, and it's unanimous in my client's favor. The 10th Circuit, the 2nd Circuit, those are high federal courts, both hold that a personal defense, such as insufficient service of process, is personal to that defendant and can't be raised by a different defendant.
Should that apply to a defendant, though, that is a successor in interest that stands in the shoes for all purposes, thereafter?
Well, why wouldn't it, Your Honor? And we'll get to some of those issues too. But if it were a merger, I could see it differently because then it would be the same entity. But there is no exception in the law in any jurisdiction that allows one defendant to challenge the sufficiency of service on behalf of another based on a successor in interest theory or otherwise. I think it's telling that the law on that issue is unanimous, and it's telling that my opponent ignored that argument altogether in its answer brief. Completely ignored the issue.
Counsel, here's my issue with this case, and I think the panel that heard this case the last time it was up had the same issue. At the end of the day, your client acquired a property subject to a mortgage, and through sleight of hand, service by publication on a company that the world knew had gone into receivership, was acquired by the FDIC, you're attempting to convert that purchase subject to a mortgage to a fee simple title. And it seems to me that whatever mechanism the trial court used to right that wrong was the right thing to do. And I guess I'm troubled by the high and mighty tone that you're taking when it seems like the equities are entirely on that side of the room. I mean, so help me understand why the result, if nothing else, is not the right result.
Well, with all due respect, Your Honor, I struggle with the entire premise of your question because you don't get to make a results-oriented decision just because you think, this might be, from a big picture perspective, the result that should happen. We operate in a system of laws, and let me give you an example. The Florida Supreme Court in La Mer, the holding of that case was to say that a final judgment which eliminated a first mortgage could not be vacated as void as a matter of law, and it affirmed the in-bank unanimous 4th DCA decision, which held the same thing, where a junior lien holder filed a quiet title suit and eliminated a first mortgage, where the bank sat on it for more than a year. The holding of the Florida Supreme Court was to say that final judgment quieting title eliminating the mortgage remains in place. So I get that there are aspects of that fact pattern that you might not like, but with all due respect, we're here, I'm asking the court to follow the law. I emphasized that issue in the initial brief, and so we can't operate in a legal system where we just disregard the law because we think,
But,
well,
but
bank
the
should
law,
see this case.
the law is insufficient service is no service, and the judgment is void. Is that not the law?
Judge, as I get through my false premises, and you're accepting those false premises when you make that statement. The first false
I'm
premise.
just asking a question.
No, I disagree that that's that what you said.
You
there
disagree
is-
that that was a question? Did I not raise the tone of my voice enough to show you that I was asking a question? I'm asking a question. Is that the law, that insufficient service of process is effectively no service, and thus the judgment is void?
Not
Question.
if the service was regular on its face. The only way that it's void is if the service was if the affidavit of service was insufficient on its face. This was not an affidavit which was insufficient on its face as a matter of law. The Florida Supreme Court has spoken on this issue in multiple cases. The Klinger case, the Coaster versus Sullivan case in 2015. All you have to do to have an affidavit which is regular on its face is conclusorily track the statutory requirements. That's it. If you track the statutory requirements, even in a conclusory fashion, the Florida Supreme Court says that is sufficient. Why does that have to be so? Because as the Florida Supreme Court and Fourth UCA ruled in that Lemaire case, you can't have situations where final judgments get vacated as void years after the fact. In other words, if I were to accept the way that Your Honor asked that position, what you're necessarily saying is that I should go to
Wait a second. You asked for oral argument, or I'm not sure who asked for oral argument, but we're here and we're asking questions because we're trying to figure out what the law is. So nobody's trying to trick you. Nobody's trying to set up false premises and cheat you. These are legitimate questions to find out what the law is. So please treat them that way.
That's what I'm attempting to do. So the next, and the false premises are not from the court. They're from my opponent in terms of the arguments that they're making. The first issue on appeal, they ignore it. I write a brief with the first issue and they totally ignore it. Then the next problem is that their entire premise of their argument is that we have some obligation to go search for a different defendant who was not named in the proceeding in order for service to be valid on the defendant that we did name. There is no legal authority at all that supports the proposition that we have had some obligation to go find or figure out or somehow assess that this loan had been transferred to a different entity. None. Every case that they cite stands for the proposition or deals with facts regarding the sufficiency of service on the named defendant. There is no obligation in the law to try to figure out who a different defendant is. Now, I'd start with the recording statute, 695.01. The entire purpose of the recording statute is to prevent what happened here. They never recorded an assignment of mortgage for years. The entire purpose of that statute was to prevent situations where someone comes in years afterwards and says, well, we're really the owner of this, or we're really the true owner. For instance, in Hull, the Florida Supreme Court.
No one ever recorded a satisfaction of the mortgage.
And that's why a lawsuit quieting title was filed as to Washington Mutual, which was the mortgage holder of record. All they had to do was file an assignment. That's what the law required. Think about this in a slightly different context. Can you imagine a context where a homeowner comes in and files some sort of quiet title suit based on a cloud in a clouded title, and somebody comes in afterwards and says, well, I had a deed, I had title to this, I just didn't record the deed. Years later, they come in and say, I didn't record the deed. That person would clearly lose.
Let's talk about the sufficiency of process. I mean, is it your position that, even though you personally either had constructive or actual knowledge that Washington Mutual was no longer, and that you attempted service on an entity that you knew was not intact?
Sure.
How can it be the case that that is sufficient service of process? When the plaintiff knows, let's take it, if the defendant is dead and the plaintiff knew that, or if the business entity has been extinguished through bankruptcy or some other means, if the plaintiff knows that or counsel knows that, shouldn't that inform whether the process was sufficient?
Well, if there's a death, you can't sue a dead person. In that event, there'd be an estate name or
Correct.
something to that effect, and that's not my niche of law at all. But, okay, there is nothing in the law that says that where this entity ceases to exist, that there is some obligation that I go figure out who the successor entity is. That doesn't exist. And that's one of the false premises that their entire argument is predicated upon. And they want you to accept not only that I had to go figure out who the successor was in general and that there was some sort of asset sale, but also that I knew that this particular loan was sold to Chase.
So there was no requirement of diligence whatsoever. So knowing either actually or constructively that Washington Mutual was extinct, you had absolutely no requirement to do any kind of search whatsoever. Is that your position?
I don't believe there was any obligation to do a search for Chase or whoever the successor was. What the law says should have happened is it's that entity's obligation under the recording statute to record an assignment. That is how it works, because that way, that's the built-in search. People in my position don't have to do a search. You go to the public records and you say, there's an assignment recorded. That's the whole purpose. It's no different than if someone in the deed context, somebody didn't record their deed and then tries to come in later and says, well, I should have been part of that proceeding because I had a deed. If you didn't record your interest, you'd lose.
I guess a cynic might say that somebody in your position would go out and look for these situations where you have a homeowner's lien being foreclosed and you have a failed bank as the mortgagee or mortgagor, and you hit 1 out of every 10 and you do pretty well. I mean, a cynic might say something like that. How would you respond to the cynic?
I'd say that if one time a Florida court followed the law, but what I submit is the law via a published decision that said the bank loses because it didn't record an assignment of mortgage, and that's what the law contemplated in order to protect its rights, that the banking system would change the way that it operates on that fact pattern, and you wouldn't have 10 cases where a cynic could say you'd succeed on 1 out of 10 because they would record assignments and the issue then wouldn't happen anymore. But we shouldn't operate in a way where the law just gets changed because we don't like the result of a bank not getting to enforce a mortgage that it didn't care enough about to record an assignment regarding. I also think it's important to note, even if we had known about Chase and there being an assignment to Chase, there was nothing indicating that this particular loan was sold to Chase at all. There are 2 4th District decisions which make clear, even with these same
Mr.
parties.
Stopa, you can keep going, but you're into your time you're trying to reserve. Okay.
Even with these same parties, they reversed because there was no proof that particular loan was part of the asset sale. Those were Cruz and Snyder, 2015 and 2016. There was no indication this particular loan was sold or assigned or transferred to Chase. That's why it should have been fixed by an assignment. So with that, I'll save the rest for rebuttal. Thank you, Honors.
Morning, Your Honors. May it please the Court. Aaron Daniel on behalf of the appellee, J.P. Morgan Chase. The trial court properly exercised its discretion here in vacating a facially insufficient affidavit of constructive service and based on competent substantial evidence that there was an inadequate search.
So why isn't this the type of problem that the recording statute was designed to prevent?
Your Honors, our interest was recorded. Our mortgage was recorded. Under the UCC, that's all that's necessary to perfect the interest. Chase has possession of the note. In the substitution appeal, this was the issue, actually, and that's why the first issue is barred by law of the case in this case, because the issue was we were substituted, we demonstrated our interest in the mortgage with an affidavit and the purchase and assumption agreement, specifically stating this loan, Mr. Campanero's loan, now belonged to Chase. So our interest was always recorded. Under the UCC, there is no obligation to record an assignment of mortgage.
Let me say this. I don't know if I agree with Mr. Stope on everything, but what I do agree with him about is just because this thing stinks, to use the prior panel's term, that's not a reason for the trial court to set aside a final judgment beyond a year. So help me get comfortable with the rationale the trial court relied upon to come to the result that it got.
Yes, Your Honor, absolutely. And here's where we go through the standard on constructive service. Where there's a challenge to constructive service, the plaintiff has the burden to show that there was a facially sufficient affidavit and a adequate search. Now, if there's a failure of constructive service, there is no notice whatsoever, and where there is no notice, Your Honor is correct that the judgment is void. The cases that appellant is citing for the proposition that there is a voidable order upon a facially sufficient affidavit are inopposite for two reasons. First, there's
Well, before we get there, help me understand how this affidavit was facially insufficient.
Yes, Your Honor. The affidavit of constructive service was filed on January 31st, the same day as the complaint, prior to summonses being issued. In that affidavit, it says personal service was attempted. That's patently false because the summons was not at hand until a day after. The return of service indicates that there was no attempt at personal service until the day after. So that statement within the affidavit of constructive service is patently false. From the record, we can see that this is an insufficient affidavit, and so it's a void judgment based on that.
Could you address the bank's standing to raise this issue? And so Mr. Stopas has cited case law from outside Florida for the proposition that a separate defendant cannot raise the issue. Does that apply to successors in interest, and have you located any case law contrary to Mr. Stopas on that point?
Your Honor, I believe this is covered by the first appeal because we had a substitution of parties based on our interest in the loan. And these arguments should have been raised at that time, challenging the interest that Chase had in the loan. I believe Your Honor is correct that substitution based on 1.260 is proper. And again, that was decided in the prior appeal. So what we're here today to talk about is the 1.540 motion that was properly granted.
So the last appeal, in your view, was simply resolving the question of whether Chase gets to participate in this proceeding at all.
Correct, Your Honor. That was
And
the
trial
argument.
court said they can, and this court affirmed.
Correct.
And so then we go back to determine, now that Chase is participating, can it get relief or not?
Correct. And Your Honor, actually, maybe some of the procedure will clear up some of your questions. Chase actually tried to vacate before substituting in, and the lower court said, I'm denying that as moot because you're not a proper party defendant. Come back, show me you're a proper party defendant, and I'll let you in so that we can adjudicate this 1.54 motion. Chase did that. There was an appeal. Issue was put to bed, and now we're just deciding 1.540, which was properly granted. We've discussed that our mortgage was never satisfied. What more could he have done? He could have not filed this complaint. When a junior interest holder sees that a superior mortgage has not been satisfied, there's no basis for filing a quiet title action, Your Honors. I mean, that's really where the rubber meets the road in this case, and there has never been a adequate explanation.
Would it be, even though there's no notice of satisfaction having been filed, if you could make a good faith allegation that that mortgage has been satisfied, I guess your argument wouldn't be so bright lined, would it?
It would not be bright line, and that's what I was getting to. There's never been a good faith argument put forward. There's never been any argument put forward. The only argument, I believe, for why the junior interest holder here can jump a senior mortgage was something about the statute of limitations. That came out for the first time in the oral argument in the prior appeal. But the running of the statute of limitations doesn't extinguish a mortgage. The mortgage under the statute of repose exists for 5 years beyond the...
Well, hadn't the Florida Supreme Court subsequently resolved that issue?
Yes, Your Honor. And even before the Florida Supreme Court resolved that in Bartram, this wasn't even an issue of extinguishing the mortgage. It was, can the mortgage holder foreclose outside the statute of limitations. So there was never a question of extinguishing the mortgage. That was never a valid basis for extinguishing the mortgage in this case.
Help me understand why I know there's maybe no obligation to record an assignment of mortgage, but why isn't that done? I mean, when the FDIC took over Washington Mutual, why isn't that done as a matter of course to put the world on notice that, you know, that's not the company that owns this anymore. It's somebody that takes it through the FDIC.
Well, Your Honor, the world was on notice, actually. There was a notice with the FDIC. The FDIC had a notice up that now Chase is the successor in interest. And we cited a voluminous case law from 2008 all the way up to when the complaint was filed detailing that notice. So the proper procedure under the UCC is, and under the governing federal laws, is FDIC takes over a company, then the notice is with the FDIC. And then, as a matter of course...
Are you suggesting there's some federal statute that trumps Florida's recording statute?
No, Your Honor. No, Your Honor. I'm saying the UCC in Florida is what governs recording the interest, and that there was a notice to the world through the FDIC. I wasn't suggesting there's a preemption issue here at all. No, Your Honor. And why, yes, there is no requirement that we record an assignment of mortgage, but it would be extraordinarily costly, and to require recording a mortgage across the board at this level, I mean, the cost of that's going to fall on the homeowners in terms of larger interest rates. I mean, you know, the banks are going to incur the costs of recording an assignment every time something is transferred, and these securitized instruments are transferred routinely, frequently. And so I think this is a policy decision that the legislature has already made by saying the UCC controls. You don't have to record an assignment of mortgage. We're not going to put that cost on the borrowers and the homeowners.
But is that not, though, a risk that the S&E assumes by this type of situation occurring? I mean, what if Washington Mutual had not gone under? The mortgage had been assigned to Joe's bank. They serve properly Washington Mutual, who just doesn't defend. Default is entered, wiping out the mortgage, and you know, would the Joe's bank just be out of luck in that circumstance?
No, Your Honor. They're under the UCC. Their security interest, their mortgage, is perfected upon possession of the note. The mortgage follows the note. And so to suggest that somehow a mortgagee, an assignee of a mortgage, to protect against frivolous lawsuits to quiet that title should somehow do some gratuitous recording acts is quite a tenuous position for the appellant to be making here. So, Your Honors, we would respectfully request that you affirm this proper exercise of discretion based on competent and substantial evidence, and allow this case to proceed on the merits so that we can dismiss this quiet title action. Thank you.
May it please the Court. So going to Your Honor's question of my opponent, how is a litigant in my client's situation supposed to litigate if there is a good faith belief that the mortgage has been paid or not enforceable for some reason? We certainly had a good faith.
Is that this case, though?
Well, yes, we had a good faith argument based on the statute of limitations. The fact that the Florida Supreme Court ruled differently years later doesn't change the fact that at the time it was made that was a good faith argument, and they've waived any fraud argument based on not filing it within a year. Lemaire, the Florida Supreme Court, rules that failure to state a cause of action isn't a basis to unwind this, so they're limited to the argument of sufficiency of service of process, which they can't do on behalf of a different entity. Their argument that, well, we intervened, so that somehow means that we're allowed to, that there's already a ruling on this issue is just wrong.
How do you respond to their argument that is really law of the case? Because the last appeal was about Chase being able to participate.
Well, they argued that here for the first time in this oral argument, not in the brief at all. But that's not law of the case, because the panel, sounds like you watched that oral argument, was very clear in ruling that all they were doing was allowing the intervention. They didn't rule on the propriety of allowing Chase to challenge service of process. There was nothing there that allowed Chase to challenge service of process. All it said is, we're going to let you go file whatever you're going to file. And in fact, one of the panel members at the time even said, we're going to let you go file it and we'll see how it fleshes out. So that's not law of the case. That's why they didn't even brief or argue the issue, and they have no case law to support it at all. So how does a litigant in my client's situation take the position that this mortgage has been satisfied or shouldn't be in place when it's a defunct bank? They take the position that we have to somehow track down and figure out who the alleged successor is. That's just not the law. That's just not the law. And that's why this court should put aside what you characterize as the stink factor, follow the law, and say they should have recorded an assignment. They didn't. We litigated with the correct entity, and they don't get to come in afterwards and challenge service of process and say, well, we should have taken these steps to track somebody down. Your Honors, this was a diligent search. I employed the effort, the knowledge that I knew at the time to engage in a diligent search, and the testimony and evidence was undisputed in that regard. They had nothing to the contrary. This court should reverse. Thank you.
Thank you, Mr. Stoba. Thank you both for your argument. We are going to take a break and have coffee in the rotunda. Counsel, please join us.
All rise. You may carry on.